Hello, hello, hello. My name is Lakshmi Challa, and today is Challa Law's weekly Wednesday webinars. Today is May 4th, and we've got some exciting news to talk about EAD extensions and answer your most pressing questions. Let's give people a few minutes to join, and I hope everyone's doing well. I want to give my parents a big shout out. Today is their 59th wedding anniversary. Wow. It truly is an amazing thing for a couple to be married that long. And what I love about them is through their imperfections, everyone's got imperfections, they still have a zeal for life. They go grocery shopping together. They look at YouTube for cooking and then make meals together. And it's just, they're a testament to all of us that, you can still discover new things as long as you understand that that discovery of new things and fun things is a journey together. So happy anniversary to them. And to our very best friends who also have an anniversary today, the Khannas. So I want to wish them a happy anniversary too. They're also an amazing couple. Who constantly tease each other, joke with each other, and it's just a blast to be around them. So wishing them, Archana Rajiv, a happy anniversary as well. Both couples, May 4th must be an amazing day because these are two to really look up to and say, that's exactly what marriage is all about. So let me see. I guess we can go ahead and get started. People will join when they can. So as I said, great news about the EADs. Now, in order to reduce backlogs, one of the things the USCIS has done has said, hey, we're going to extend EADs. Remember, there was an automatic extension already for 180 days. Now they've extended that for an additional 360 days for all those who were eligible. Now, in order to leverage this, what the USCIS said is they've been in a precarious financial situation that has impaired their efficient completion of cases. And then the COVID pandemic really, exacerbated this, and they haven't been able to recover as of yet. So there was an automatic extension for 180 days, and they've increased it to 360 days, which is a total of 540 days for eligible participants with timely filed. Timely means before the expiration. So let's just make sure we understand that. Timely filed I-765 renewals, and it applies to, H4s, L2s, E1s, E2s, E3s, and of course, adjustees and others. And if your renewal application 180-day extension expired before May 22nd, you can still receive the benefit of the temporary increase of your employment authorization, and your EAD would automatically resume beginning on May 4th for any time remaining up to the 540-day automatic extension. To calculate whether there's any automatic extension remaining, count 540 days from the expiration date on the front of the EAD. And employers, what they would do for I-9 purposes is, take a copy of the EAD and the I-797C, which is the receipt notice that the EAD was filed, the extension was filed before May 4th, and states the normal and 180-day period. So you would get the 180-day plus, not an additional 180-day, whatever's left of your 180-day, plus the additional 360. Non-citizen, people with pending EAD renewal applications whose 180-day period has lapsed and whose EAD expired will be granted an additional period of 360 days beginning May 4th. So they can resume employment if they're still within up to the 540-day extension period. And automatic extension will be granted upon the notification of the final decision up to the end of the 540 days. So that is great news. It's at least an additional, 1 year in addition to the 180 days. So it's a year and a half. And hopefully the USCIS can issue EAD cards within that year and a half, right? Next, the NVC reported their April 2022 update, where they have stated that they currently have 453,797 cases ready for interview as of March 31st. Wow. And the interview cases scheduled for April is 32,000. So if you look at that number, there were 421,358 pending in April compared to the 437,700 in March. So they really haven't increased the interviews. The backlog is only increasing incrementally by maybe 3.5%. The total of number of green cards interviewed increased by less than 0.4%. So I don't know, unless they substantially increase their processing times, we're looking about 10 years to get back to pre-COVID levels. And that is the main news for this week. But it was pretty significant that we had that one to report. So we are ready to start with our Q&A. We ask our moderator to join if he is not busy. There we go.
Good afternoon, Lakshmi. Looking good.
How are you? You look a little, your hair's looking a little crazy.
Yeah.
That
air conditioning
plus
breeze and the fan breeze is too much.
Yeah, and the ridiculous heat in Chennai.
Yeah. Okay. Let's see. I think I have a. All right. I got to choose between the two because the timestamp is the same. So I'm going to go to the chat. Chandra Venkatadri. My priority date is November 2012 in EB2. Last year, July, I have downgraded my EB2 petition to EB3 and filed I-485 EAD AP petitions. All these petitions are still pending currently. And 4 weeks back, my employer Intrafiled the pending I-485 of EB3 to EB2 as priority dates move forward in EB2. So my 180 days of AC-21 job portability rule is started again regarding changing my employer.
Mm-hmm.
Now, will it be possible for me to change my employer by just ignoring this Intrafiled I-485 petition in EB2? For unexpected problems with my current employer, now I like to join a new employer by filing 485J supplement form and porting my I-485 of EB3. Will it be possible to carry forward my GC process EB3 with the new employer?
No, you have to wait for the 180 days. It's just like with when you originally file your I-485 and I-140 and you have to wait the 180 days. It could be that just after you file it, you don't want to work for that employer. But AC 21 says it's got to be pending for 180 days. Same thing when you, file a new I-140. Same trigger, same rules.
Okay. So the next one is from the Q&A box. Anonymous attendee, are EB2 straight refile 485 cases being transferred from National Benefit Center to Texas Service Center if the applicant also has a pending EB3 downgrade from October 2020 and EB3 I-140 is pending at SRC? Is this a current trend you are noticing?
I know we were going to look into that. I don't know if Ashley is on the call and whether she's had a chance to even check that out. We were going to look into seeing whether, that is an issue. I haven't heard of that. But, if you haven't joined our Telegram group, please do, because as soon as we hear something, we'll post there. But unless one of my team members, kind of pipes up, let me see. I don't know whether that would, but we're looking into it. It takes time to kind of see if it's a pattern or an instance. It's hard to determine that nowadays, just given the erratic way in which the USCIS is processing things.
Okay. This question is from YouTube, Mandeep Raj. Why is it taking a lot of time to get the receipts generated?
Yeah.
I filed LOS on April 4th and still no receipts. Are you seeing the same issue with applications filed by your firm?
Yeah, I mean, receipt notices across the board are, and I'm glad you brought up that question. So one of the things you can do is when the USCIS accepts your file and they enter it into a system, they have to cash the checks. They'll cash the checks before they even issue you a receipt notice. So if either you or your attorney filed the petition, ask them to look on the stamp at the back of the check their bank, and it won't give you a receipt notice, but it'll give you a receipt number. That'll give you some, comfort that it was received.
All right. People are just trickling in, looks like, on a Wednesday afternoon. It's in the summer, not summer there. I wonder how hot it is.
Spring.
Rich.
It's nice. It's beautiful weather here.
Glad to hear. Because Chennai is close to 87 degrees.
Right. We can see that on your face. So.
All right. Next question from the Q&A, anonymous attendee. Is USCIS holding off adjudications of straight EB2 cases with EB2 I-140 approved if a downgrade EB3 I-140 is pending for the same company?
Those cases are processed parallel, so one won't be held back because of the other. At some point, they'll ask you to choose, but one won't be held back because of the other.
All right. Next question from Aditya Kiran Chenojwala. Hello, team. My wife is on E3D visa. E3D visa? Not heard that before, but stamped in March 2023 and recently entered US, and I-94 still says E3D and valid until 2024. How do I get to change to E3S, and does it affect her EAD? Do I need to apply EAD once I-94 is changed to E3S? Our current E3D EAD is valid until March 2023. Thank you for your time.
What did the USCIS, I mean, did the visa say E3D? Is that why?
My wife is on a E3D visa stamped in March 2023.
Right, so E3S is for, so you must be an E3, so E3S. And you said that she was stamped with, what did?
E3D.
Oh, okay. Well, it won't affect but you probably, let me see something, hold on. I'm trying to see if there's a quick way to change it. So to tell you that, she won't have a problem. E3Ds are usually for spouses of E3s. I always get those classifications mixed up, but E3D is for E3 spouses. So she was stamped with an E3D. I think that should be okay if you're an E3 spouse.
All right. Aditya, if you have further questions, just send an email to info@challalaw.com.
Right.
Mandeep Raj is back asking for a friend. What happens if EOC is filed for primary applicant, but not able to file for dependents because they are out of the country?
Right.
And I go ahead and file for myself and later add dependents to AOS. Also, what happens if I get GC before I could file dependents application?
Right. So they can only file, anyone can only file an adjustment of status if they're in the United States. That's a jurisdiction issue. So dependents that are overseas, you have to wait till they return. Given the processing time, I don't know when yours has been processing or you've gotten biometrics, but if their plan is to stay for an extended period, I would suggest that they come back and apply for their adjustment. And if they want to go back, they can go back if they've got another non-immigrant visa, either L or H non-immigrant visa in their passport. So I don't know what the priority date is. I don't know how long it's been pending. I don't know if biometrics, but those are the things I would look at to try to get some assessment as to whether, when they should come back. But you don't want to lose that opportunity.
He's saying that not able to come back because of visa stamping issue. No BM PD is current in final action chart.
What, aren't they eligible for Dropbox? If they've had a visa before and
no appointments.
Appointments are for the visa interview, but Dropbox doesn't need an appointment. Lainey's gonna upload our information on Dropbox appointments. Take a look at that, and I think that may help you.
He says for Dropbox also appointments are needed.
Oh, that's weird. They must have instituted that recently, because usually Dropbox, you don't need appointments. Let me check into that and get back. I mean, that's a whole idea of having a Dropbox. That seems strange to me. Let me look into that and get back to you.
Aditya is following up and saying the E3D and E3S use, saying it's regarding work authorization. The S is the classification you need for incident to status work authorization.
Oh, you're talking about the EAD classification. Okay. not the visa classification. You're talking about the EAD classification, right? So one is incident to status. And I think they only allow, yeah, so L's and E2s are eligible, or maybe all E's are eligible for incident to status. I thought it was only E investors and E traders. I didn't think it applied to E3s, but I may be wrong. I know L2s are now incident to status. So that means if somebody's incident to status, they don't have to apply for work authorization. Let me just check. Get the next question while I look at this.
Yeah. Currently on H-1B and applied for 485 straight case in April in EB2 and received the receipts. If I travel to India, will it abandon my I-485 if I leave before AP is approved? Also, what happens to my pending 485 if my H-1B visa appointment results in a 221G and I'm stuck in India for a long time?
Right. So to get back, E3s are incident to status. And that should be notated on the I-9 form. So you may want to call USCIS and just tell them that they made a mistake. She's got a work authorization document, so that should not impact it, but you kind of want to make, she doesn't really even need one because the I-94 should have the class of admission. You're right, as E21S, E2. Yeah, so it should have. So you may want to go back to the port of entry. I mean, it shouldn't because all E's are eligible for incident to status, but you just want to make sure that it is the correct one. So the best way is if the I-94 was issued incorrectly, you go back to the port of entry and you show them evidence, that you qualify for this status and make sure they reissue the I-94 card. Because for incident to status, the I-94 card would rule as work authorized document. So you want it to say the S. You want it to say S. Okay, go ahead.
Question from the Q&A box from an AA. What is the pattern for transferring I-485 from Texas to NBC? Did Texas Service Center stop processing I-485?
Right. So if Texas has already started reviewing, they will. The rule is they're going to transfer the cases to NBC, and the exception is if they've either started reviewing the I-485 or they've started reviewing and they've issued an RFE. So those are the ones that will be kept with the Texas Service Center.
All right. This next question is from YouTube. Hi, I have a question regarding U visa. I'm an international student on F1 visa, but I've been harassed by my ex and have been a victim of identity theft. So should I consider U visa or stick with H-1B route?
When you say you've been harassed, there has to be, for a U visa, there has to be certain types of crimes that fall under that. So mere harassment's not enough. There's got to be an assault. So unless there was an assault that was reported, because remember, a U visa, it's that you are being a resource to the police in an ongoing investigation. So if there's blackmail, false imprisonment, assault, stalking, if you've reported any of these to police and there's been a charge that's been filed against that person, then you could be eligible for the U, but not for identity theft.
Okay. That's all for now, unless people are thinking what to ask.
Well, I want to, while we have the folks up, let me see, does it show me to show more? I was trying to upload my links.
While you're looking at it, I just wanted to tell the viewers about EB5 visa, the new regulations, and if any of your friends, relatives, neighbors, well-wishers are interested in EB5, they can reach me here in India. I'm in Chennai for the next 2 weeks. I'll be glad to talk to them. Regular phone call, WhatsApp call, email. I can do a Zoom or a Blue Jeans call, video call. Anything is possible. So just send an email to info@challalaw.com, and in the subject line you can say EB5 help. It'll come to me and I'll take care of it.
Perfect. I was going to.
There's a question on the Q&A box. Does pending I-485 status get abandoned if your H-1 visa stamping is denied and you have not received your AP yet? What are your options at that point to get your green card? Consular processing?
Say that again?
Does pending I-485 status get abandoned if your H-1 stamping is denied and you have not received your AP yet? And what are your options at that point to get your green card? Consular processing?
Right. If you're traveling and you don't have, and it would be really unfortunate if for some reason your stamping was denied, that would really concern me, because usually that's, at this point, that should be very routine. But yes, then you have no way of coming back into the United States without your AP. But if you could send me some details about why or if this is just a hypothetical, then that's fine. But if it has been denied, if you could send us some information at info@challalaw.com, that would be great. And Lainey, if you could share the links on the Q&A, that would be fantastic for our social media. We've got a great Telegram group. We broke the news yesterday to the Telegram group as soon as we heard about the EAD. So it's a great community of people. So please join our Telegram group. We've got, of course, this weekly webinar. We'd appreciate it if you'd share it with your friends. And then we've got a number of other social media, mediums that we use to communicate with you. One of them happens to be YouTube. YouTube is chock full of really good information that you can use to research or look at any subject that you're having some questions on. So check those out. Lainey sent the links. And so we would love to hear from you. We will be back next Wednesday at 12 p.m. Eastern Standard Time. I want to thank my team.
I got some questions still from YouTube, just came in.
Okay.
Sweet Seller is back.
I was wondering why we didn't get a question from Sweet Seller.
We have a B2 visitor child visiting US. The child is not eligible for COVID vaccine. Is test mandatory for travel to India from US?
Yes. You'd have to look on the Department of State exceptions depending on the age of the child. But I know personally that, and it depends on the airlines. I think most it's within 24 hours you have to get a COVID test before you can board a flight to the United States. But I'm sure their age.
I think, I think they were asking from US to India.
There's no, I just flew back, unless it's something that came up in the past 3 weeks. But if you're not vaccinated, you'd have to check the website to check. And those things keep changing, folks.
Yeah.
Those things keep changing, folks. It's fluid. It's not static. So before your trip, like I said, I could tell you from personal experience, check the website and figure out what the requirements are.
Yeah, check the website, read all the website pages very clearly. And if required, if time permits, call the airline too. We are talking from personal experience.
That's it. I want to thank all those joining from YouTube as well.
Another question from Funny K. Any change the DOF filing moved to August 2015 in EB2 anytime this year?
I have no idea. Like I said, there's all sorts of crazy things going on. As I've been stating, Q3 would give us a better indication of what they're processing every week. And so let's take a look at that next week. And
the last question from the box, sorry.
I was going to say you interrupted, but I don't think that Q3 will be issued until after June. So go ahead.
So we'll take this last question, and if we can't answer your question, please do send an email to info@challalaw.com. This from AA, have 2 I-485s pending, one in EB3 and EB2 each. Have received AP from the EB3 application, but not the EB2 yet. Does using EB3 AP affect the EB2 I-485 pending case currently on H-1B status?
No. In fact, they probably won't even process your AP and EAD for the other filing because they've already issued it, an AOS, AP, and EAD, which would be valid for either. So no, you are in good shape to use that.
All right. That's about all.
Great. And I'm glad I was able to say something positive at the last question. Thank you all again. Thank you, YouTube. Thank you, Lainey, for all your hard work. Thank you, Mr. Challa, staying up and
thank you,
moderating. And look forward to seeing you all next week. Next Wednesday, 12 p.m., Challa weekly webinars.